Swayam Prabha. Digital India. Educated India.
So moving forward in trying to come to the last leg of understanding part 3 of the Constitution, which deals with fundamental rights, before we touch upon constitutional remedies under Article 32, uh, we have the right to freedom of religion under the Indian Constitution. And I think while the preamble does talk about secularism or a secular state, which means the state shall not have a religion of its own, and citizens are free to exercise their own religious freedoms under the Indian Constitution. So, Article 25 does say that the freedom of conscience and free profession, practice, and propagation of religion is allowed. However, this is subject to public order, morality, and health. Friends, India has had a great heritage for religious harmony. I think people from different religions have lived peacefully, harmoniously for many years now in this country. This country has welcomed all forms of religion. And you will notice that with the refugee status given to the Dalai Lama, I think Buddhism also has now become an integral religious part of the Indian country. Now, friends, religion is usually some kind of a matter of belief or faith, and the Constitution of India recognizes that this belief or faith has to be protected, and you should get the freedom of religion. And hence, there are at least four articles that are dedicated: Article 25 to Article 28, that deals with what I would say ensuring or securing the secular model of governance in the Constitution. The Indian Supreme Court has time and again come in terms of trying to interpret uh, these freedoms, and the apex court has, in the Keshavananda Bharati, which is the basic structure doctrine, it had said that secularism is a basic feature of the Constitution, and hence I think the state will protect the rights of citizens in all religion. Um, to be honest, if you read Article 25, it says nothing in this article shall affect the operation of any existing law or prevent the state from making any law, which may regulate or restrict any economic, financial, political, or other secular activity which may be associated with religious practices. Which means the state can make law in the matters of religion, uh, especially in trying to regulate or restrict economic, financial, political, or other secular activities. Um, so, state can also go ahead in providing social welfare and trying to reform, or in trying to throw open Hindu religious institutions of a public character to all classes and sections of Hindus. So, in terms of caste, religious institutions cannot actually regulate. So, the state can actually make a law. So, the rule of equality, I think, applies over here, because you will notice that the state shall treat all religions equally as a principle, and all persons are equally entitled to the freedom of conscience and the right to freely profess, practice, and propagate their own religion. However, propagate would not mean conversion. Explanation 1 to Article 25 says that the wearing and carrying of kripal, which the Sikh do, shall be deemed to be included in the profession of the Sikh religion. So, as a matter of constitutional recognition, kripal can be carried by Sikh. They're permitted to do so as a part of their profession. Explanation 2 says that the reference to Hindus shall be construed as including a reference to person professing the Sikh, Jain, or Buddhist religion, and the reference to Hindu religious institutions shall be construed accordingly. So, Sikhism, Jainism, and Buddhism are an integral part of Hinduism under the Constitution of India. Uh, So, while we talk about the requirement of a uniform civil code in this country, this has been a debate. You will notice that Article 44 of the Constitution of India requires us to make such a law called the Uniform Civil Code, because many often than not, it is the religious laws that determine your personal space, your personal life, your family life, including inheritance and succession. So I think while there is a rule of equality that the state must treat all religions equally, you will notice that this obligation of the state is to also ensure that every citizen within that religion is also treated equally. Uh, of course, you will notice that there are some very interesting issues that were addressed under Article 25, which means that there is something called an institution that is called the Anand Marg. Now, Anand Margis have the right to perform Tandava, and this was held in this case of 1984. So it was considered part of their what we call as the essential religious practice. Right now, this is a doctrine that the Supreme Court has evolved, that if it is an essential religious practice, it can be protected under the right to freedom of religion. But if it's not so very essential religious practice, then it cannot be protected under the right to religion. The best case scenario to explain this is the use of loudspeakers. There is a case called the Churches of God Full Gospel versus KKR Majestic Colony Welfare Association, AIR 2000 Supreme Court, where the court said that no religion prescribes that the prayers should be performed by disturbing the peace of others, nor does any religion preach that they should be using during their religious activity voice amplifiers or the beating of the drum. Such kind of practice, which adversely affect the rights of others, cannot be included as essential religious practice, thereby getting protection under Article 25. So I think it's very clear that use of loudspeakers under the ambit of right to religion, profession, practice, and propagate will not be permitted. So generally, the state is not allowed to interfere into someone's religious belief by any chance, but it may be required on the ground of public order, morality, and health. And environment and health go hand in hand. Uh, you know, to be honest, we have the case of the national anthem, which was also there. We will discuss this case when we discuss Article, yes, Article 28. Because see, Article 28 very clearly says freedom as to attendance at religious instructions or religious worship in certain educational institutions. So, no religious instruction shall be provided in any educational institutions wholly maintained out of state funds. No person shall be forced into any kind of religious practices in state aid institutions. So, a case called the Vijay Emmanuel versus State of Kerala case. This is popularly called as the national anthem case. What happened in this case was three children belonging to a sect called the Jehovah's Witness worshipped Jehovah. He was considered to be the creator, and they refused to sing the national anthem Jana Gana Mana. Now, according to these group, singing Jana Gana Mana was against the tenets of the religious faith, and which did not allow them to sing the national anthem. These children stood up respectfully when the national anthem was being sung daily. They stood in silence, but they did not sing because they believed this, as per their religion, is the honest belief that they cannot sing the same. A commission was appointed to inquire the matter, and in the report, the commission stated that these children were law-abiding and did not show any disrespect. However, the headmistress, under the instruction of the deputy inspector of school, expelled the students. The Supreme Court held that expelling the children for not singing the national anthem violates the freedom of religion. Fundamental rights guaranteed under Article 19(1)(a), which is the freedom of speech and expression, and Article 25(1) has been infringed in this case. It was further held that no provision of law must compel or obligate anyone to sing the national anthem, and it is also not disrespectful if a person stands during the singing of the national anthem. So I think the singing of national anthem has been an issue quite recently as well. we had a Supreme Court judgment which said that national anthem should be played at the beginning of every movie that is being screened, and it expected citizens who went to the theaters to stand during that national anthem so that some kind of patriotism can be shown during such public assemblies or public gatherings. So this has been some kind of a issue under right to religion. Where do you balance the interest of right to religion and the right of patriotism, national security, integrity, and so on and so forth? Um, yes. Now, under Article 25, as I told, there can be some restrictions that can be imposed. Now, you will notice that public order uh, as a restriction appears in two parts of the Constitution, and they should probably mean one and the same thing. It appears in Article 19.2 of the Constitution. So, public order means your freedoms on 19.1 are subject to the restrictions given under Article 19.2. So, the freedom of speech and expression, the freedom of movement, they are subject to public order. And here also, the right to religion is subject to public order. So, in your religious practices, if you are going to infringe any kind of public order, to that extent, your right to religion will be subservient and it can be curtailed, restricted, regulated as well. Um, See, communal violence in our country has been a kind of a challenge for the state to address. I, I assume that the frequency of communal violence has reduced in the last couple of decades, but this was quite a prevalent issue for the state to manage. Now, when temples and other religious institutions are affected by frequent communal violence, the state is duty bound to maintain public order. This is something that religious institutions can claim as a matter of their freedom of religion. Because communal violence affects your religious practice, your religious faith, your religious ceremonies. And if the state does not maintain law and order, freedom of religion itself becomes completely redundant and irrelevant. Um, See, while the courts have said that religion is a matter of faith, but the belief in God is not essential to constitute a religion. And they have said that the doctrine in each religion, what is so essential and what is not, is left to different religions for them to actually determine. Also, the courts have said that the philosophy of the religion is different from the religion itself. So, I think time and again the courts have tried to look at the various dimensions to religion, what religion actually is faith, philosophy, and religion essentially different, then it can be considered to be so. Um, okay, I think this could be, yeah, I think one of the issues that have been is about gender equality or gender equity that religious institutions are expected to follow. Because when you're talking about a public premise or a public temple, then you can't have the right of admission reserved. You cannot take matters into your own hand and determine who can enter and who cannot enter a temple. There were controversies of Yesudas trying to enter the Guruvayur temple. There was controversies about whether women can be priests in Hindu temple. There was controversy about can women enter Shabrimala temple as well. So this essential religious doctrine now has become a very important doctrine for the Supreme Court to determine what should be protected or what I would say should be excluded under the garb of freedom of religion and what should be permissible in terms of the public character of such places and institutions. Uh, I will speak about one interesting case called Aditya versus Travancore Devasthanam Board. It was a case about a non-Malayali Brahmin to be appointed as a priest in a temple in Kerala. The court held that as long as a person is well versed, properly qualified, and trained to perform the puja in any appropriate manner and worship the deity, then such person should be appointed as the pujari of the temple despite his caste. So, caste cannot be the basis of determining who the priest in the temple is, and hence it was observed that temple is not a denomination where there is a specific form of worship that is required by a particular caste, and hence a qualified, well versed, and a trained pujari should be permitted to perform puja in the temples as well. Of course, taking over of certain Hindu temples has been challenged as being constitutionally valid or not. And you will notice that in certain places, the right to perform puja by a particular kind of a community was abolished. For example, in the Kashmir Mata Vaishno Devi Shrine Act of 1988, this was done. And the administration, governance, and the management of the shrine was vested in a board instead of a family that was actually managing that kind of a shrine. So the Supreme Court held that such kind of an act where the state takes over and denies a particular family or a group of individuals from managing a shrine or a temple can be considered to be constitutionally valid, and that family, after the temple has taken over, cannot claim the right to do the puja. So the state, in public interest, can always take over that. Of course, whether triple talaq has an essential religious practice connotation in Muslim law and can be protected under Article 25 as the freedom of religion, practice, profession, and propagate, I think the courts very clearly have said that this is a practice in the Muslim community, and in a 3-2 majority, the court ruled that the practice of talaq-e-biddat is illegal and unconstitutional. The court held that an injunction would continue to bar Muslim men from practicing triple talaq till a legislation is enacted for this purpose. So later on, you will notice that the government did formulate a law for protection of rights of women in marriage, especially in Muslim law. And triple talaq now has become an offense, and that is how probably what the Supreme Court did was, I think, morality and health were part of the kind of restriction that you can exercise on freedom of religion. So, in the name of religion, any kind of atrocity, any kind of discrimination, any kind of harsh, illegal, irregular treatment of women can definitely be regulated by the state. Uh, Very recently, in a case called Indre noise pollution case, uh, you will notice that the main issue, and this arises very time and again, especially in the month of November, was whether firecrackers can be used during Diwali. Now, in a city of Delhi, which has had a very long history, more than 3 decades of history of very bad air pollution, the government of Delhi has banned firecrackers. Initially, they regulated it, then they banned it. In between, there were green firecrackers, but still they were polluting and emitting. It was affecting right to health. So, in general, when the state makes a law in larger public interest, and they may want to ban a particular kind of activity, seize certain kind of equipments or certain kinds of issues. This is largely done in terms of controlling air and noise pollution. Now, during your essential freedom of religion, if that practice of religion is affecting the larger community and the larger environment, then a complete ban on firecrackers can be justified. So, public order, morality, and health. Now, health is critical, isn't it? So, do firecrackers affect right to health? Does it affect right to clean air and environment? The answer is an absolute yes. So, burning firecrackers or killing the effigy of Ravana during some of these Indian festivals can be controlled and restricted, or you can look at certain kinds of eco practices to exercise your freedom of religion. So I think the courts have come heavily down on these kinds of management of religious affairs by community, and they have very clearly said that religious denominations have to adhere to the guidelines of the Supreme Court, because the larger health of the community is something they are bound to respect and follow. Uh, of course, there have been some criticism saying, why only Hindus have to have these restrictions and why not other religions. But I don't think that is a fair argument to make. I think it is better to look at the objectivity of the intervention of the court, and I think the objectivity of the court is very well established, saying that there can be a ban, complete ban on firecrackers, especially at peak air pollution time. And that is probably the time when Diwali comes, so it's okay. I think right to health of communities and people have to be given paramount protection under the Indian law. So, moving on, friends, let's look at Article 26 of the Constitution of India. Article 26 of the Constitution does allow for freedom to manage religious affairs to any section of the community, and the right to establish, maintain institutions for religious and charitable purposes. Now, you will notice that as a religious institution, you can have your own, you can do your own affairs. You can own and acquire movable and immovable property, and you have the right to administer such property in accordance with law. So while Article 25 guarantees the right of individuals to profess religion, Article 26 allows institutions to have the freedom of religion. So that is the difference mainly between Article 25 and Article 26. So Article 26 is protecting what we would call as the collective right of a particular denomination of religious people or citizens. And please note, while we say that Article 26 is for collective exercise of right to religion, it is also subject to public order, morality, and health. And that's why the Supreme Court has always said this, that there are three conditions to be completed before the freedom under Article 26 can be exercised. First, that the collection of individuals who have a particular kind of a belief, or who believe that they are in one spiritual congregation. So they have to have that kind of a belief that they belong to one sect or one community or one kind of religious belief. They should have a common organization, and they must have a distinctive name. And for example, the Supreme Court has said that Ramakrishna Mission can be exercising the right under Article 26. The Anand Margis, as I told you earlier, are also a religious denomination within the Hindu religion itself. And the Arbindo Society, unfortunately, has been held not to be a religious institution. So, while Ramakrishna Ashram and Anand Margis have been given their protection under 26, Arbindo Society is not considered as a religious denomination. Uh, then moving on, if you look at Article 27, Article 27 clearly lays down that lays down that no person shall be compelled to pay any tax for the promotion and maintenance of any particular religion. So there is a kind of a tax exemption, and while we look at maintaining secular order, we should also maintain the fact that while religious denominations need not be taxed, the state shall not spend public money for the promotion and maintenance of a particular religion. That is also something that has to be clearly looked into. But remember, Article 27 of the Constitution says that it prohibits the levy of tax, but not fees. So, which means there is a difference between tax and fee. And sometimes, to look at what we call a secular administration, some kind of a fee may be part of what can be levied to say those who are attending a religious event. For example, if you are taking some kind of Char Dham Yatra, or if you are taking the Yatra to the Amarnath caves, then can the government charge a particular kind of fee? The answer is yes, it can. That is not considered to be a tax in that sense. So, of course, there is an expenditure that is involved by the state to take the pilgrims from one destination to another, to take them safely, and to see that the yatris don't suffer any kind of harsh weather or harsh conditions. The government has to take certain kinds of steps and measures for which a fee can definitely be levied on the pilgrims, and this is important to give them, say, some services, It could be medicine, it could be hospitals, it could be food, and so on and so forth. Or it could be taking such safety measures to reach the holy place or holy cave, as in the case of the so-called Shivlinga, which does exist in the Amarnath caves. Going on further, you will notice that there is another article called Article 28. Under this article, no religious instruction shall be provided in any educational institution which is maintained wholly out of state funds. I think this is also a very, very important declaration under the Constitution of India, and it clearly says that state aided institutions must be secular and they shall not have religious instructions so as to infringe the rights of students from other religion as well. But please note, there are religious institutions which are called or managed by endowment trust, and endowment trusts not necessarily are the ones that receive state aid or state funding. So, in such kinds of institutions, religious instructions can be imparted. But when state funds are received, the secular character of the educational institution shall be maintained at all instances. So you will notice that Article 28 makes a distinction between four types of educational institutions. First and the foremost, it says those institutions wholly maintained by the state, institutions that are administered by the state but established under an endowment or a trust, institutions recognized by the state, and institutions that receive aid from the state. So you can make a distinction where Article 28 applies, and you will notice that you can't administer religion to a minor without his consent or without the consent of a guardian. So these schools must refrain from religious instructions unless they have been permitted to do the same as a private endowment or a private trust. And please note, the private endowment and the private trust has been established for imparting religious instruction itself. So that is the main purpose. So once you have that kind of recognition, then you can go ahead and impart such kinds of instructions. Now, you must see that in India, it is not only about religious instructions in stated institutions that is to be looked at in schools, but also in terms of universities as well. So that that, for example, we have an institution called the Aligarh Muslim University. Aligarh Muslim University was established under a legislation in 1920. And while we say that Aligarh Muslim University is for Muslims, that is not the exact purpose of the university itself. So, being brought through legislation, this is not an institution that can promote only one religion. It is not an institution where religious instructions can be imparted. Having said all of that, one can always look at Article 29. Article 29 and Article 30 are two very interesting articles. One that talks about protection of the interest of minorities, especially in managing their cultural and educational rights. So you will see that Article 29 provides that any section of citizens residing in any part of India and whatever distinct language, script, or culture they may have of their own shall have the right to conserve the same. Right. So I think minorities, we can say that either they're linguistic minorities because they may be from a small region with a small language of their own. They may be cultural minorities because they are a small sect of community which has a distinct culture within a given state already. Because initially, when states were made in India, they were made on linguistic lines. And then we subdivided it based on even cultural aspects like the hilly region as against the plains. So when Uttarakhand was crafted from Uttar Pradesh, it could be both based on cultural and other kind of criteria that was required. But what Article 29 very clearly protects and provides is that you shall have the right to preserve your language, your script, and your culture. And this is part of a citizen's right under the Constitution. Further, please note this article also, in one sense, states that no citizen shall be denied admission into an education institution maintained by the state or some institutions that receive aid from the state on the grounds of race, religion, caste, or language. So there cannot be discrimination in state aided institutions on the basis of religion, race, caste, and language. So education institutions have to open their doors and treat everyone equally, and hence discrimination on the ground of race or religion or even caste or language. There are four criteria over here cannot be done by state aided institutions. Um Article 29 grants protection to both religious minorities as well as linguistic minorities. Because remember, religious minorities could differ from one state to another. For example, in the state of right now, as we call as the Union Territories of Jammu, Kashmir, and Ladakh, Hindus may be a minority. So when you look at all over India, Hindus may be a majority, but if you look at one particular state, there could be one religion that people of that religion who can be considered as minorities. So as soon as you come within that kind of kind of a status of being a minority, you can claim the protection under Article 29. Further, linguistic minorities can also claim protection, and the Supreme Court has held that the scope of this article is not necessarily restricted to minorities as we commonly assume them to be. Uh, so it has to differ from state to state, from region to region. And if some kind of a minority community wants to protect its language, then you will notice that there is a provision in the Constitution to recognize such kind of languages, and the conservation of any language shall amount to the rights of the citizen under the Representation of Peoples Act 1951 as well. Article 30, as we see, is the right of minorities to establish and administer education institutions. So 29 is about, look, you can protect your culture and you can protect your language. And to do so, can you establish and administer educational institutions? Article 30 grants this kind of right to both religious and linguistic minorities. So they can establish and administer educational institutions of their choice, uh, and they can look at acquisition of property. They can hold such property, and this is guaranteed to them in terms of what we call as the protection of minority rights. And the state has a duty and an obligation not to discriminate against education institutions that are especially managed by minorities. So please note, while we talk about Article 30, it is very clear that Article 30, the right to establish and administer education institutions, is not a general right. It is only a right given to minorities. So I think the majority population cannot claim the right under Article 30. Please note, again, you will notice that here, again, you can make a distinction about those institutions that seek aid from the state, those institutions that seek recognition from the state. And so the distinctions are majorly there. And in a lot of cases, you will notice that the kind of syllabus that are prescribed in some of these minority institutions can be a subject matter of the regulatory power of the state. So, can the state lay down standards of education in these minority institutions? Can the state lay down employment in these minority institutions? Can the state prescribe the syllabus or the academic kind of curriculum that is required? I think you will notice that the state definitely has a regulatory power, though you have a right to establish. So you cannot say that the state shall not, in any way issue guidelines, which could be guidelines such as guidelines on labor law, guidelines on taxation, and so on and so forth. So I think the state definitely can lay down those kinds of rights while the citizens have the right to establish these educational institutions. Um, right. Uh, there is some autonomy for institutions under Article 30. The autonomy is that these minority institutions can decide who their governing body should be. They can decide the rules and regulations and what kind of faith or confidence they should have in the management of the affairs of the institutions or who should manage it. I think they can decide. They have some autonomy in terms of appointment of teaching staff, who should it be, and they can take action against such kinds of staff that have shown dereliction of duty. They can admit students of their choice and set up reasonable fee structure, and they can use their property and asset to benefit the institution. So these are some kind of autonomous powers that are granted to institutions established under Article 30. Uh, of course, please note Article 30, while it gives this right, it is the duty of these education institutions to ensure equality as far as possible within that minority community itself. And they must provide the opportunity to even the disadvantaged citizens in that minority community. Uh, so I think it's important that they understand that while there is a fundamental right given to establish, they should not violate social welfare. They ought to not create any law and order situation. Health and other national interest are something that these institutions must adhere to. So I think the character of minority institution is that they have to be subservient to the constitutional goals, and the welfare of students and teachers will be paramount. And any kind of regulation that the state makes on the welfare of students and teachers have to be adhered to by the minority institutions fully. Of course, you will notice that if these institutions, in some form, have been getting aid from the state, then all the guidelines that the state imposes for such institutions have to rigorously be followed. So you can exercise all your rights, but this is the condition based on which these rights are to be exercised and also reasonably enjoyed. So I think with this, we should kind of conclude the provisions of the Constitution. We conclude what we call as the fundamental rights in Part 3, except what we would go next is what is known as the constitutional remedies for the infringement of your fundamental rights. And these are available under Article 32 and Article 226 of the Constitution of India. So these are, in terms of violation, what happens, right? In terms of infringement of a fundamental right, what happens is what is there in the next module.